Hello and welcome to today's episode, which deals with the meaning and characteristics of the business regulatory framework. The episode also provides information about the different aspects of the Contract Act 1872. In addition, the episode also explains the role of acts and aspects of the business regulatory system as applicable in India, keeping the present business scenario in mind. I am Amrita Ghosh Kumar, and the subject expert for this lesson is Dr. S. Meraj, who has specialized in human resource management and is currently teaching in Amity University. Let us begin with a broad overview of the concept of business regulatory framework. Introduction. The law of contract is that branch of law which determines the circumstances in which promise made by parties to a contract shall be legally binding on them. All of us enter into a number of contracts every day, knowingly or unknowingly. Each contract creates some rights and some duties upon the contracting parties. The Indian Contract Act deals with the enforcement of these rights and duties upon the parties. The Indian Contract Act 1872 came into effect from 1st September 1872. It extends to the whole of India except the state of Jammu and Kashmir. A contract is a voluntary agreement, whether verbal or in writing, between two or more parties, that creates a legal relationship and is enforceable by law. Section 2H of the Act defines the term contract as any agreement enforceable by law. There are two essentials of this Act: agreement and enforceability. Section 2E defines agreement as every promise and every set of promises forming the consideration for each other. Again, Section 2B defines promise in these words: when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. Proposal, when accepted, becomes a promise. Contract as per Section 2H. A contract is an agreement enforceable by law. Thus, contract is equal to agreement plus enforceability by law. However, all contracts are agreements, but all agreements are not contracts. Agreement as per Section 2E. An agreement means every promise or every set of promises forming consideration for each other. Thus, agreement is equal to promise or promises made by one party plus promise or promises by the other party. Definition of promise as per Section 2B. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Therefore, promise is equal to proposal plus acceptance. Definition of proposal or offer as per Section 2A. A person is said to make a proposal when he signifies to another his willingness to do so or to abstain from doing anything with a view to obtaining assent of that other to such act or abstinence. Thus, proposal is equal to willingness to do or abstain from doing plus willingness to obtain assent of the other party to such act or abstinence. Definition of consideration as per Section 2D. When at the desire of the promiser, the promise or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act of abstinence is called consideration. Essential elements of a valid contract as per Section 10. Agreement. To constitute a contract, there must be an agreement. There must be two parties to an agreement. That is, one party making an offer or the offerer, and the other party accepting the offer or the offeree. consensus ad idem, meeting of minds. To constitute a valid contract, there must be meeting of minds, that is consensus ad idem. The parties should agree to the same thing in the same sense and at the same time. Intention to create legal relationship. When the two parties enter into an agreement, there must be an intention by both parties to legally bind the other as a result of such an agreement. Capacity of parties or competence. The parties to the agreement must be capable of entering into a valid contract. Every person is competent to contract if he or she 1. Is of the age of majority, 2. Is of sound mind, and 3. Is not disqualified from contracting by any law to which he is subject. Lawful consideration. An agreement to form a valid contract should be supported by consideration. Consideration means something in return or quid pro quo. It can be cash, it can be kind, an act or abstinence. It can be past, the present or the future. However, consideration should be real and lawful. Free consent. To constitute a valid contract, there must be free and genuine consent of the parties to the contract. It should not be obtained by misrepresentation, fraud, coercion, undue influence or mistake. Lawful object. The object of the agreement must not be illegal or unlawful. The consideration or object of an agreement is lawful unless it is forbidden by law or is of such nature that if permitted it would defeat the provisions of any law, or is fraudulent, or involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. Agreement not declared void or illegal. Agreements which have been expressly declared void or illegal by law are not enforceable by law. Hence, does not constitute a valid contract. Certainty and possibility of performance. The terms of agreement must be certain and not vague. Offer and acceptance. Sections 3 to 9. Offer or proposal. A proposal is defined as when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence. He is said to make a proposal. For example, 1. A offers to sell his book to B. A is making an offer to do something, that is to sell his book. It is a positive act on the part of the proposer. Number 2, A offers not to file a suit against B if the latter pays A the amount of rupees 200 outstanding. Here the act of A is a negative one. That is, he is offering to abstain from filing a suit. An offer can be made by an act in the following ways. A. By words, whether written or oral. B. By conduct. The offer may be made by positive acts or signs so that the person acting or making signs means to say or convey. Number 1. A proposes by letter to sell a house to B at a certain price. This is an offer by an act by written words, that is the letter. This is also an express offer. Number 2. A proposes over telephone to sell a house to B at a certain price. This is an offer by act or by oral words. This is an express offer. Now let us look at the essential requirements of the valid offer. 1. The offer must be made with a view to obtain acceptance. 2. The offer must be made with the intention of creating legal relations. 3. The terms of offer must be definite, unambiguous, and certain or capable of being made certain. The terms of the offer must not be loose, vague, or ambiguous. Number 4, an offer must be distinguished from A, a mere declaration of intention, or B, an invitation to offer or to treat. Number 5, the offer must be communicated to the offeree. Number 6, the offer must not contain a term the non-compliance of which may be assumed to amount to acceptance. Number 7, a tender is an offer as it is in response to an invitation to offer. Now let us look at the termination of an offer. 1. An offer lapses after stipulated or reasonable time. 2. An offer lapses by the death or insanity of the offerer or the offeree before acceptance. Number 3. An offer lapses on rejection. Number 4. An offer terminates when revoked. Number 5. It terminates by counteroffer. Number 6. It terminates by not being accepted in the mode prescribed or in the usual and reasonable manner. Number 7. A conditional offer terminates when the condition is not accepted. What is acceptance? When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted, as per section 2b. Thus, acceptance is the act of giving consent to the proposal. A proposal, when accepted, becomes a contract. A trader receives an order from a customer and executes the order by sending the goods. The customer's order for goods constitutes the offer which was accepted by the trader by sending the goods. It is a case of acceptance by conduct. Here, the trader is accepting the offer by the performance of the act. Now, let us look at the essentials of a valid acceptance. Number 1, acceptance must be absolute and unqualified. Number 2, it must be communicated. Number 3, it must be according to the mode prescribed. Number 4, it must be given within the time specified or within reasonable time. Number 5, it must be in response to offer. Number 6, it must be made before the offer lapses. And number 7, it must be given by the person to whom the offer is made. Now let us look at the capacity of contract as per sections 10 to 12. Every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. Thus, incapacity to contract may arise from 1. Minority, 2. Mental incompetence, and 3. Status. Now let us look at the position of a minor's contracts. Number 1, a contract with a minor is void ab initio. Number 2, a minor's agreement cannot be ratified by the minor or attaining majority. Number 3, a minor cannot be asked to refund any benefit received under a void agreement. Number 4, a minor is not estopped to plead minority even where he falsely represents himself to be of full age. Number 5, a minor cannot be a partner in a partnership firm. He may, however, be admitted to the benefits of an already existing partnership. Number 6, a minor can, however, be a promisee or a beneficiary. Now let us look at what is mental incompetence. A person is said to be of unsound mind for the purpose of making a contract, if at the time when he makes it, he is incapable of understanding it and of forming a rational judgment as to its effect upon his interests. Definition of lunatics. A lunatic is a person who is mentally deranged due to some mental strain or other personal experience. Now, who is an idiot? An idiot is a person who is permanently of unsound mind. He does not have lucid intervals. Now let us look at incompetence through status. An incompetency to contract may arise from political status, corporate status, legal status, etc. Consent as per section 13. It is essential to the creation of a contract that both parties agree to the same thing in the same sense. When two or more persons agree upon the same thing in the same sense, they are said to be of consent. A agrees to sell his Fiat car 1983 model for rupees 80,000. B agrees to buy the same. There is a valid contract here since A and B have consented to the same subject matter. Consent is said to be free when it is not caused by A. Coercion, B. Undue influence, C. Fraud, D. Misrepresentation, and E. Mistake. Now let us look at coercion as per sections 15, 19 and 72. Coercion is, number 1, the committing or threatening to commit any act forbidden by the Indian Penal Code, or number 2, the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into an agreement. For example, a Hindu widow is forced to adopt X under threat that her husband's corpse or dead body would not be allowed to be removed unless she adopts X. The adoption is voidable as having been induced by coercion. As per Ranganayakama versus Alvarsetti, undue influence. Sections 16 and 19a talk about undue influence. Undue influence consists in the improper exercise of a power over the mind of one of the contracting parties by the other. A contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. For example, A having advanced money to his son B during his minority, upon B coming of age, obtains by misuse of parental influence a bond from B for greater amount than the sum due in respect of the advance. Here A employs undue influence. What is fraud as per sections 17 and 18? Fraud means and includes any of the following acts committed by a party to a contract, or with his connivance or by his agent, with intent to deceive another party thereto or his agent, or to induce him to enter into the contract. 1. The suggestion as a fact of that which is not true by one who does not believe it to be true. Number 2, the active concealment of a fact by one having knowledge or belief of the fact. Number 3, a promise made without any intention of performing it. Number 4, any other act fitted to deceive. Number 5, any such act or omission as the law specially declares to be fraudulent. Definition of misrepresentation as per sections 18 and 19. Misrepresentation is incorrect or false statement, but the falsity or inaccuracy is not due to any desire to deceive or defraud the other party. It is innocent. The party making it believes it to be true. For example, X learns from A that Y would be the director of a company to be formed. X tells this to B in order to induce him to purchase shares of that company, and B does so. This is misrepresentation by X, though he believed in the truthness of the statement and there was no intent to deceive, as the information was derived not from Y but from A and was mere hearsay. Mistake. Mistake may be defined as an erroneous belief concerning something. Mistake is of two kinds. 1. Mistake of fact, and 2. Mistake of law. Mistake of fact. A. Bilateral mistake, when both the parties to the agreement are under a mistake of fact essential to the agreement. The mistake is called a bilateral mistake of fact and the agreement is void. B. Unilateral mistake. A contract is not avoidable merely because it was caused by one of the parties to it being under a mistake as to a matter of fact. Mistake of law as per section 21. A. Mistake of law of the land. A contract is not voidable because it was caused by a mistake as to any law in force in India. And B. Mistake of foreign law. The mistake of foreign law is to be treated as a mistake of fact. A mistake as to a law not in force in India has the same effect as a mistake of fact. The meaning of consideration as per sections 2D, 10, 23 to 25, 148 and 185. Consideration is what a promiser demands as the price for his promise. When at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or promises to abstain from doing something, such an act of abstinence or promise is called a consideration for the promise. For example, A agrees to sell his house to B for rupees 10,000. Here B's promise to pay the sum of rupees 10,000 is consideration for A's promise to sell the house. And A's promise to sell the house is the consideration for B's promise to pay rupees 10,000. Now let us look at the rules regarding consideration. 1. Consideration must move at the desire of the promiser. Number 2. Consideration may move from the promisee or any other person, that is a stranger to consideration, may maintain a suit. Number 3. A stranger to the contract cannot maintain a suit. Number 4. Consideration need not be adequate. Number 5. Consideration must be real and competent. And number 6. Consideration must be legal. Kinds of consideration. A consideration may be 1. Executed or present. Consideration which moves simultaneously with the promise is called present consideration. Cash sales provides an excellent example of present consideration. Number 2. Executory or future consideration. When the consideration is to move at a future date, it is called future or executory consideration. It takes the form of a promise to be performed in the future. A promises to B to deliver him 100 bags of wheat at the future day. B promises to pay for it on delivery. Number 3. Past. A past consideration is something wholly done, forborne or suffered before the making of the agreement. For example, A saves B's life, B promises to pay A rupees 1000 out of gratitude. The consideration for B's promise is a past consideration, something done before making of the promise. However, there are some exceptions to the rule. No consideration, no contract. The general rule of law is that an agreement without consideration is void. A bargain without consideration is a contradiction in terms and cannot exist. Now let us study legality of object as per sections 23 and 24. An agreement will not be enforceable if its object or the consideration is unlawful. According to section 23 of the Act, the consideration and the object of an agreement are unlawful in some cases. Number 1, if it is forbidden by law. A loan granted to the guardian of a minor to enable him to celebrate the minor's marriage in contravention of the Child Marriage Restraint Act is illegal and cannot be recovered. Number 2, if it is of such a nature that if permitted, it would defeat the provisions of any law. For example, number 1, A let a flat out to B at a rent of £1,200 a year. With a view to reduce the municipal tax, A made 2 agreements with B. One by which the rent was stated to be £450 only, and the other by which B agreed to pay £750 for services in connection with the flat. Held, A could not recover £750 since the agreement was made to defraud the municipal authority and thus is void. Number 3, if it is fraudulent. For example, number 1, A, B and C enter into an agreement for the division amongst themselves of gains acquired or to be acquired by them by fraud. The agreement is void as its object is unlawful. Number 4, if it involves or implies injury to the person or property of another. For example, number 1, A borrowed ₹100 from B. He, that is A, executed a bond promising to work for B without pay for 2 years, and in case of default agreed to pay interest at a very exorbitant rate and the principal amount at once. Held, the contract was void. Number 5, if the court regards it as immoral or opposed to public policy. For example, number 1, A let a cab on hire to B, a prostitute, knowing that it would be used for immoral purposes. The agreement is void. That is all for today. Hope you have understood the fundamentals of business regulatory framework. We'll see you again with another topic on business regulatory framework. Till then, take care and bye-bye.